So in this video, we're going to head to St. Croix County, Wisconsin, where we encounter the plea agreement and hearing for former fifth grade, didn't stutter, fifth grade teacher Madison Bergmann, who pled guilty to inappropriate contact with an 11-year-old. Didn't stutter again, 11-year-old. And at what age is too low for the pred supporting, protecting, deflecting, mostly men out there that think that this is just so cool behavior? How low does it go before they actually will put the brakes on and say, yeah, that is wrong. Yeah, that's weird. Yeah, that's perverted. Yeah, that's predatory. Yeah, that's a pedophile. We have gone beyond the high school. We've now gone below the middle school. And now we've entered elementary school age boys that have been sexually abused and assaulted by their teachers. And in this case, at River Crest Elementary School in Hudson, Wisconsin, St. Croix County, we've almost got what could be called a pedo cluster inside the school, inside the elementary school, where another teacher, friend of Madison Bergmann, did what? She covered up the crimes that she knew about. She was a mandatory reporter. She was initially charged with failing to report this illicit, illegal behavior as a mandatory reporter and teacher entrusted with children's lives. And then she herself, Miss Faust, friend of Bergmann, was charged with inappropriate and illegal conduct with a different fifth grader. That's right. So we're going to go to her plea hearing, listen to the judge, watch her cry and shed a bunch of tears, and listen to the prosecutor. And then we'll get ready for the sentencing hearing, where she could be sentenced to more than a decade in prison. Is it likely? Probably not, but we shall see. Let's go to the courtroom in St. Croix County, Wisconsin.
Bergmann is going to enter pleas of guilty to count 3, child enticement. There is a lifetime supervision of serious sex offenders. Enhance her on that at this time. She's also admitting to that. Count 6, sexual misconduct by school staff, and count 8, sexual misconduct by school staff. Based on those pleas, the state is moving to dismiss but read in all of the other counts for purposes of sentencing. We are jointly recommending a PSI be done, and the state is to cap their in-custody recommendation at 12 years at the time of sentencing.
Ms. Bergmann, do you understand what's proposed?
I do.
Would you stand up, raise your right hand, and
here come the tears.
Do you swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
You're going to have to speak up.
Self
Yes.
you God, that was
Okay, have a seat. Thank
so
you.
help you God.
Bring that microphone up close to you so that way I can hear you and everyone else can, okay?
Yeah.
Thank you. So first of all, with regard to counts 3, 6, and 8 in the amended information, which are child enticement with lifetime supervision of serious sex offenders, sexual misconduct by school or staff or volunteer, and sexual misconduct by school staff or volunteer. They are Class D and Class I felonies, the latter two. What is your plea today?
Guilty.
All right. In order for the court to consider whether to accept your guilty plea, I need to ask you some questions. So first of all,
Are you on
complete
drugs?
this plea questionnaire and waiver of rights with your
Did you
lawyer.
drink?
I did.
And is this your signature and your lawyer's signature on the second page?
It is.
Now, did you have a chance to talk to Mr. Tamburino about the plea questionnaire?
Yes.
Tambo.
Did you get all your questions answered?
I did.
Counsel
Currently
Tambo.
receiving any treatment for mental illness or disorder?
No.
Have you had any alcohol,
stable.
medication, or drugs in the last 24 hours?
Yes.
And what have you had?
I've had my prescribed
Did she
medication.
claim
Okay, and
HIPAA?
are you taking it according to the prescription?
Yes.
Is there anything about that medication that you know of that would affect your ability to understand what we're doing here in court today?
No, Your Honor.
Next thing we need to talk about are the elements of these particular crimes.
Well,
And we'll start with
what more can be
child
said?
enticement,
You sent
which is count 3.
35,000
Now here's why we're doing this.
messages with an
One of
11-year-old.
the reasons, though, is you're offering a guilty plea on all 3 of these charges.
Guilty.
And you're giving
Plea,
up
not
the right
pleasure.
to have a trial and make the state prove up each of these elements. So I want you to know what it is exactly they would have to prove if we did go to trial, since you're giving up that opportunity, okay?
Yeah.
All right. So first of all, with regard to child enticement, the state would have to prove that you attempted to cause a person to go into a secluded place, that the person was under the age of 18 years, you attempted to cause the person to go into the secluded place with intent to have sexual contact with a child in violation of Wisconsin Statute 94802. In addition, because the allegation...
I
is
think
this is an attempt,
35,000 text messages would help prove that.
the state would also have to establish that, that you intended to cause the person...
I mean, just imagine this. To me, I can't even picture 35,000. I mean, have you all exchanged that many messages with your mom, your dad, your wife, your husband, your girlfriend, your boyfriend? I mean, my goodness, 35,000 messages. And we saw this with the New Jersey teacher, Allison Haverman, Friedrich, something long, different names that she could then hide and shield her identity. But Allison something. Thousands, tens of thousands. I mean, this is where, you men out there that are a little bit lonely and not getting messages from women, from the ladies, we know where some of their attention is now, with tens of thousands of messages and emotional and romantic and sexual messages to a 5th grader. I mean, how does that make the single population out there of men that are looking for women feel? That you're sitting lonely at night playing video games and this woman's texting to the tune of 35,000 messages, a young boy. Crazy. And she was also had a fiance. And, to show you this type of relationship, we'll throw some of the pictures up, or we'll have thrown some of those pictures up of this relationship. Crazy. Tens of thousands. And some people can't get women to respond to one message. They
go into the secluded place for the purposes of committing one of the listed crimes, and I've stated the one that was alleged by the state. The defendant did acts that demonstrate unequivocally, under all of the circumstances, that she had formed that intent, and that the defendant did the acts that demonstrate unequivocally, under all of the circumstances, that he or she would commit the crime, except for, in this case, there's the intervention of another person or some other extraneous factor. So those are all the elements of this particular crime. And there's one more, and that would be that it has to occur in St. Croix County. So, counsel, have we got that correct?
That's correct, Your Honor.
That's correct.
All right. So, do you understand all of the elements of the child enticement crime that I've just described?
Yes.
Now, the next 2 charges are identical in terms of the charge, but they allege, as I understand it, differing dates?
Different dates, Your Honor.
Okay. So let's go through, I'm going to go through the elements in general.
It's
and
like
then
turn
we'll
up her
specify
volume.
dates.
Your Honor, turn up your volume. We can barely hear you, sir.
So first of all, this is sexual misconduct.
Muffled mic. You got the
against a
worst
pupil
mic.
By a school staff member under 948.098. The first thing that the state would have to prove in connection with these two charges is that on the specified date, you were a school staff member at, in this case, River Crest Elementary School. On the specified date,
Pedo
the
cluster.
victim was enrolled at River Crest Elementary School as a pupil. And a third, you committed an act of sexual misconduct against the victim. Now, sexual misconduct under the statute means verbal conduct of a sexual nature or physical contact of a sexual nature. The allegation here is verbal.
Correct, Your Honor.
Correct?
Correct.
35,000's
Verbal
worth of
conduct
verbal.
a sexual nature means communications made intentionally for the purpose of, and in this case, I'm assuming to facilitate the crime under 948.02. It wasn't specified.
Correct, Your Honor, for sexual, the intent for sexual contact.
Okay.
Crystal clear mic from
Now,
the attorney
The last thing I
section.
want to mention here is the stated purpose that's referenced under the statute, for which the intentional conduct needs to be established, is for the sexual arousal or sexual gratification of the victim or yourself. Those are the two that seemed applicable to me. Is that right, counsel?
That's correct.
Correct.
And intentionally means that you acted with a mental purpose to achieve those results. So, in addition to all of that, it would have to be established this happened in St. Croix County as well. So, counsel, can we confirm, I know it's a relatively new statute, and I just want to confirm that we've got the elements correct to your satisfaction.
Satisfied.
Agreed.
The next thing we need to talk about are the penalties for these three charges. Now, count 3, child enticement, and I think counsel has already pointed out that that includes lifetime supervision as a serious sex offense as well. But the penalty under Class D felonies is imprisonment of up to 25 years and up to
Whoa.
$100,000 fine. Do you understand that?
Yes.
Now, with regard to the other two charges, those are
25.
Class
Let's
I
add all these up. Let's
for
add
which
these
the
up.
maximum imprisonment is 3 years and 6 months and a $10,000 fine. Do you understand the penalties that would apply to each of those other two charges?
Yes.
Now, this is
3 and
one of the most important moments, I think, in our
I guess
plea
3
policy.
years and
I
6
want
months
you to
plus 3 years and
understand
6 months is 7 years.
that regardless of
32
what's
years of
recommended
exposure.
here by the attorneys, whether it be now or at a sentencing hearing later, I could still sentence you up to the maximum penalties that I've just described for those three crimes. Do you understand that?
Yes, Your Honor.
Yeah, she doesn't believe it. No way in her world does she think that she can get probation. She's going to be walking out of here on
Charges
probation.
are proposed to be dismissed and read in for purposes of sentencing. There's a total of
So,
10.
very unclear here. I'm not an attorney. I'm not offering legal advice, but I do understand legal information. There's a difference between consecutive and concurrent. A judge completely didn't explain that if she were to be concurrent or consecutive, she could be sentenced up to 32 years in prison, according to my math. And let's
Charges
see
in
what
the amended information.
dumping the
So
other 10
you're
charges.
You're offering a plea to 3 with 7 to be dismissed and read in. It's important that you understand
Read 'em in.
what that means. You heard me just describe what the maximum penalties are. For
But
the
you didn't
three
describe consecutive
charges
or
of
concurrent
guilt.
at all.
I can't
So-
sentence you to any greater penalty
And we know you would never
based upon
dare do
dismissed
that,
and read
even
into
by
it.
accident,
All right?
in 32 years.
But I can consider the circumstances surrounding those other charges as I determine what the appropriate sentence is for those three that you've offered your guilty plea on, within the limits of the maximum sentences that I just described. Do you understand that?
Yes.
Based upon your plea today to the child and child.
Even a fifth grade teacher can follow along on this one.
Mr. Tamburino points out the requirement
No,
for sex offender registration as well. That's not even part of
slight
our plea
against
process. It's not
elementary school
required to
teachers.
be.
Critical
But
part of
you are
K through
fully
12
aware
educating the youth.
that this particular charge requires, as mandatory lifetime sex offender registration. Is that correct?
Yes.
That's correct.
Are you fully aware and understand all those consequences of offering your plea here today in connection with those requirements?
I do, yes.
Has anyone promised you anything or threatened you in any way to make these three pleas?
No.
Have you had sufficient time to discuss all these matters with Mr. Tamburino?
Yes.
Do you have any more questions for him right now?
Tambo did a good job.
So knowing everything you know sitting here today, and everybody you've talked to before,
Cost a pretty penny.
and all the thought process you've gone through coming here today, do you still wish
What
to
cuck
offer
dude paid for the bills?
guilty pleas to these three charges?
I do.
So based upon my conversation here today with Ms. Bergmann and my observations of her here in court, the court finds that the defendant has entered into her three pleas knowingly, intelligently, and voluntarily, with a full understanding of the nature of the three charges, the maximum penalties that could be imposed, and the constitutional rights she's giving up. The court also finds there is a factual basis for these three pleas based upon the agreement of the parties, my own review of the complaint, as well as the preliminary hearing and motion process that we've undertaken already in this case. And so based upon all of those facts, the court finds there is a factual basis to support these three pleas. The court will accept your three pleas of guilty and pronounce you guilty of count three, which is child enticement, count 6, which is sexual misconduct by a school staff member or volunteer, and count 8, which is sexual misconduct by a school staff member or volunteer. The first as a Class D felony, the latter two are Class I felonies. The remaining 7 counts are dismissed by agreement of the parties and read in for purposes of sentencing.
Knows now that the guilty pleas have been entered, she no longer enjoys that presumption of innocence that she's enjoyed up until this point.
So this nasty prosecutor, I mean, I don't want to go up against her in court. She looks like she's prepared to fight back against the notion that women get a pass when it comes to predatory behavior. She's got the full ammunition to go at this case of Madison Bergmann, knowing that it's a nationally recognized case. And of course, we can't give this, generally they want the female pride cases to get a really good deal to sort of fly under the radar. These ones that hit the Daily Mail and the New York Post, I've noticed that the more notorious the cases are, the tougher the prosecution is in ensuring that there's a just and equitable sentence when it comes to female predators. Whereas before, a lot of these cases were just, flying under the radar, probation, no sex offense, no registration requirement, no restrictions, back with your teaching license in a year in the classroom. Not anymore. This is a dispute here about they've pled guilty. She has pled guilty. And is she going to be let out on bond before her sentencing in two or 3 months? This prosecutor is making the case that no, she's pled guilty to serious crimes. She's very likely going to be sentenced to prison. She should be remanded into custody immediately. And the defense will argue differently.
She's pled guilty to 3 felonies here today, the highest level being a Class C felony. Also, as the court knows, according to the plea, the state will be asking for a lengthy prison sentence in this case. This is a case that's been in the public eye. It requires public protection.
Is that why you're
Ms.
asking for
Bergmann
a
was in
difficult
position of power within the school district, used that to an advantage on a student, and since then, the investigations have continued, as the court know, and the case and other cases have remained in the public eye. I know Ms. Bergmann has participated in therapy at least since October of last year. She has had a year to engage in that therapy. I believe she's made some progress. According to the letter that was submitted, I don't believe much
How do you
further
make progress on-
can be made or be beneficial at this stage. I believe the remand is appropriate at this time, again, without that presumption of innocence, with the prison sentence that the state will be asking for. I think it's appropriate at this time.
Since the time of her initial appearance in court back in May of 2024, the bond was set. She posted the bail as well as the bond, and she's remained out of custody. She was on a GPS device, a global positioning system device, and she maintained full compliance with every aspect of her conditions of release. She never violated it one time. She and her family had separate housing for her with her grandparents to accommodate that. She kept working. She never had contact with children. She kept in contact with me constantly. So did her family. Mr. Bergmann is here in court. She has had supervision like basically no other defendant through this process.
Fill the pews
has
with
had.
support.
Additionally,
Not for the victim.
on her own, she sought help. Not only
for the
did she
prey.
go through therapy, it's much more than that, Your Honor. As the court might know, I submitted a letter last week to the court as well as sealed documents. So what did she do? Well, first she got a full psychosexual evaluation. That's not an evaluation where someone sits down for a couple hours and they talk and take a couple of tests. That's multi hours of going through testing over several days, as well as,
It
talking
sounds exactly
with the
like that. You
psychologist.
pay a
And based on all of
psychiatrist
those
a bunch of
testings,
money.
as we have submitted to the court and counsel, she is deemed
Certifies
not a threat
you
to the
as
public. She
healed.
has scored very well on everything.
Of course.
This evaluation was given to Ms. Otten back in July. We have had a number of conversations about this case, at least 3 meetings, and I made it clear to the state that she wants to plead guilty to some type of counts in this case. We made that clear. She wants to resolve this matter. There is
She wants to put, does she really have any choice other than, I mean, with tens of thousands of digital forensic evidence of the crimes that she committed? I mean, you're acting as though like she's doing something to, a public service and to not further traumatize the victim. And let's just be done. I'm guilty. There's a significant amount of evidence and information that she would get destroyed in a trial and would be far more likely to get a tougher prison sentence. So it's within her interest, defense counsel Tambo, for her to plead guilty at this stage.
a significant amount of information that shows that she was guilty of these counts. And she has maintained that she is guilty of these counts, and that's why she did the psychosexual. After the psychosexual, she then completed a pre-sentence investigation privately, so that the pre-sentence investigator not only works with her, but as well as go through all of her family contacts. And that's clearly established that she has maintained great ties to the community and has abided by all conditions of release. On top of that, Your Honor, as this court knows, 6 months ago, the court released her from the GPS system because she had done so well on her conditions of release. She never violated one. So for the last 6 months, she's had no GPS monitoring. And on top of that, Your Honor, it's not only therapy, it's sex offender programming. She has had, I believe at the time of the pre-plea investigation was submitted or my letter, it was 39 sessions. That is a lot of sessions, Your Honor, that someone would do even before they enter a plea of guilty, even before they admit guilt, even before there is a conviction. So basically, other than the legal issue of the presumption of innocence not applying, nothing has changed and things have gotten better. This is a person who is actively in sexual programming. So for those reasons, we are respectfully requesting
Sexual programming?
that her conditions of release remain the same. Because again,
What does sexual
nothing's gotten
programming
worse.
mean?
It's gotten even better. It's become better because of everything that she has done to try to do whatever she can to make this situation better, not only legally, as well as to admit guilt for purposes of the victims, hopefully to have some type of
Victims?
closure
There's
in this case.
more than one
as well as for her.
elementary
Thank you.
age kid?
I'm going to exercise my discretion to order that she be remanded into the custody of the St. Croix County Sheriff. Bond is going to be revoked as of this moment. And we will await the 75 days or so to get the PSI completed and find out what the ultimate outcome here is in terms of sentencing. But balancing all the factors, I think that's the most appropriate decision, proper exercise of my discretion here today. Now, is there anything else from the state's point of view that we need to address today?
Not today, Your Honor.
Mr. Tamburino?
Nothing else, Your Honor.
All right. Then I will see you at the sentencing hearing, and we are adjourned.
Well, you did your best, Tambo, but it wasn't quite enough. And cuffed up. Very rare to see a woman put in cuffs. Female predator put in cuffs. And there she goes. Madison Bergmann. That is the case out of Hudson, Wisconsin, and will be sentenced in December at some time. Very crazy case. Again, this woman had a fiance and was getting ready to start a career, continue her career in education for students, and for some reason, there's this predatory instincts in some of these teachers that either when they do this to get into teaching, or they what is going on that is turning these cases younger and younger for the victims and destroying communities and these what seems to be on the surface, these women who are just starting these careers, in many cases attractive and very smart, intelligent educators, and yet there's this element to some of these teachers that are committing these very, very serious and horrific crimes, and society seemingly is starting to catch on to come down on these predators in a very, very strict way that never used to happen. Again, and this prosecutor alluded to the fact that she's probably getting real tough on this case because it's got national attention, right? And nobody wants you're giving women better deals, way better deals, and it's a joke. And they don't want me to report on that. And many others that shows the hypocrisy. But there's also the side of society that is praising this stuff, is glorifying it. And but at what point do you draw the line, right? If it's not 17, is it 16? If it's not 12, is it 11? Is it 9? When do the pred supporting simps out there draw the line on female offenders sexually abusing boys? We will continue on. That is from St. Croix County, Wisconsin, in the courtroom, as it happened last month. And hopefully we will be able to report back to you what her ultimate sentence will be